everything in depth today. But what I'd like is for everybody to get involved and to pop your hand up if you've got any questions. Jenny will let me know, and also to put anything into the chat as well, and just to make sure that you do keep yourself on mute unless you have a question. And I'll just naturally just finish a slide and then we can come to you if you've got anything you want to ask. There are some case examples throughout, and it would be really useful if people, you know, get involved and do answer them. So just so we can keep everyone awake and you're not having death by PowerPoint. So that would be really helpful. So understanding MCA at all levels. So it's useful just to think about the aims of today, which is to understand the law when working in mental health and mental capacity, and understanding the origins and application of the law of Mental Capacity Act 2005, and also seeing examples of how this can be misused or applied in everyday practice. So we just want to talk about some of the pitfalls, some of the general things that people may be misunderstanding about the Mental Capacity Act. And all of these slides will be going out to everybody, so you can reread them and go back to them. And we do have some resources as well that you can look at in your own time. So yeah, we'll be covering that again, because sometimes some of these things are quite complex, and you can revisit them when you maybe are coming across someone who has needs that you maybe need to think about. So I just wanted to recap really the mental capacity law, how it started. So there's a couple of things that you can look into, but there was the Gillick law, Gillick competency that came in 1986, and this looked at 16-year-olds who were a 16 plus who were wanting to make decisions regarding their contraceptive care, and it was agreed as part of that there would be a need to look at the competency and understanding of the individual patient around that, and that came in 1986. There was also a case in 1990 which was around a sterilisation of a young woman who had a learning impairment, and it was felt that, you know, that was a building block for looking at that, and that all went through the House of Lords. There was also laws that could be left. So basically there was a building of cases, and then obviously it went to Cheshire West eventually, which was, it was just to explain that there was lots of building blocks that led up to the Mental Capacity Act, and that's really what we want to talk to in deep. But if you do want to look into it, there was lots of things that led to that, and I can share, and I've got some resources at the end where you can see a bit more about how that started. So what is the Mental Capacity Act? So the Mental Capacity Act 2005 is a law that protects and supports people that do not have the ability to make decisions for themselves. So it also provides guidance to support people who need to make decisions on behalf of someone else. So it's just really important that we look at that and how decision making is made. Prior to this, you know, there wasn't really something in place as much, really. Obviously we have different laws like the Mental Health Act, but it was really that we needed this piece of legislation in to help and support people's decision making, and consider all parts of that. So so what does the MCA or Mental Capacity Act apply to? So the law applies only to people who may have difficulty making certain decisions, but this must be due to a cognitive impairment or disturbance, such as dementia or brain injury. Now, this can also apply to temporary fluctuating capacity. So we might have to consider someone who may be under the influence of drugs or alcohol, or it might be that maybe someone has a mental health need that maybe only means that they are unwell for some of the time. And sometimes we may need to consider a short-term assessment of need around their cognition, or it might be that it's more of a long-term need. And often as part of the MCA, we will ask that question: are they likely to regain their understanding or capacity, or is it that it is a long-term need? So even if they have difficulty, they may not always be considered unable to make a certain decision. So sometimes more simple decisions are easier to make. And it might be that someone may struggle with the complexity of, for instance, finances or something in more detail, but that actually there are certain decisions they're able to make, such as daily decisions around their care and support, or around what they would like to eat or drink, etc. So these are things that are perhaps more simplistic, and it is about how we support to understand those other decisions as well. So this is where the law protects them. So someone can only be considered as lacking capacity to make a certain decision if they cannot do one or more of the following things. So they need to understand the information given to them around that specific decision. They need to be able to retain it. So can they hold on to that information? Sometimes we're able to look at that through coming on a couple of visits, or we might be able to check later if they've understood what we said, or if it's quite a small decision. And that's why we're looking at today, is that we can consider MCA not just a complex decision, but we can consider it on a more simplistic level as well. And we need to know, do they retain that information? So do they, for instance, around something small and like what they wanted to eat, and can they retain that later? So that's something we might need to look at. And they also need to weigh up the information available to make the specific decision. And we're going to go into that in a little bit on what that might look like and what information they might need to be thinking about that shows evidence that they understand that decision, and some of the things we might want to think about. And then it's also how they communicate their decision, which could be through any other means. It can be, some people may be not able to verbalize, but they might be able to clearly give information. So we need to show how we can communicate with people with different levels of need as well. So we're going to go through that a bit more detail today. So I just wanted to go back to the basics really of just the MCA principles. So this is what's written within the Mental Capacity Act. There are 5 main principles. So principle 1 is that we must presume capacity of someone. So every adult has the right to make his or her own decisions and must be assumed to have capacity. So we must assume that someone can make that decision unless we are able to clearly prove otherwise. And so this means that you can't assume someone cannot make a decision. And obviously this is something we'll come to in a moment, but you know, often we hear the term, oh, they don't have capacity, but it's not clear what they are referring to. They're just stating, I don't think they have capacity, but we need to be very clear on what that means. And there has to be clear evidence and a legal framework to say why we feel they don't, and a clear assessment, because, you know, as with anyone, it wouldn't be fair to assume that about anybody and remove their rights. So someone can't make a decision for themselves just because they have a particular medical condition or disability, and we can't assume that just because of that need. Principle 2, individuals being supported to make their own decisions. So a person must be given all practicable steps. So it might be through communication or support. It might be through going to see them at a certain time of day. You know, I've seen assessments, I'm the MCA lead as well, and I do see assessments where maybe someone has gone to see someone late afternoon when they have dementia, and that may lead to increased confusion with some people who maybe develop that kind of sundown presentation, and they may be more confused at certain times of the day. So we need to make sure that when we do these assessments that we've taken all practicable steps, and that we may be seeing them at the right time with the right support. And it has to be that we are making every effort to encourage and support people to make their decision for themselves. If we're not sure, we need to return and we need to have that conversation again. You know, we need to be making sure that it's clear that we are, that, you know, maybe it's borderline, we're not sure, we need to go back. Could they have had more support to help them to understand that information? Then we need to look at it again. So if the lack of capacity is established, it's still important that you involve the person as far as possible in making the decision. So even if someone, when we're clear they don't really fully understand, and maybe we don't think they have the full capacity to understand it, we should still be considering them as part of the whole process and making sure that they're involved, and see what their wishes are around that particular decision. So principle 3. So this is where someone is able to make unwise decisions. And you know, day to day, lots of people, I'm sure all of us have made different decisions, which we have the right to make unwise or eccentric decisions. We can do with that as we need to. And that's everybody's human right to do so. And everyone has their own values, beliefs. And it might be that the person that you assess or the person you see, you know, they might be maybe living in a bit of a messy home, and that's their decision. They prefer it that way. But we can't put our values and beliefs onto that person. We need to make sure that they are, you know, we are considering that as part of it, and they can make that unwise decision. So just because we don't necessarily agree, it doesn't mean that you can treat them as lacking capacity for that reason. So we need to make sure that that bias is not being affected, and we're not saying that just because of that decision. But I think sometimes what we do see in social services and in the support that you will provide is that sometimes maybe is placing them at harm, and that's where it might get escalated for us to do a full mental capacity assessment. And with principle 4, best interests. So we're going to be doing a session tomorrow, which is tomorrow afternoon, which is with Marla Karasu, and that's looking at the best interest checklist and how we apply that. So we'll be talking more about that tomorrow, but I'm touching on it briefly today. But if a person has been assessed as lacking capacity, then any action taken or any decision made for or on behalf of the person must be made in their best interest. And there's a series of steps that you can do to look at that, which we will go into a little bit today and then more tomorrow. And then finally is principle 5, which is that we need to look at the less restrictive option. So someone making a decision or acting on behalf of a person who lacks capacity must consider whether it is possible to decide or act in a way that would interfere less with the person's rights and freedom of action. So, you know, we need to think about what are all the things that we can consider within this and what would be the least restrictive to them. You know, we don't put someone maybe in a full care home when they have lower needs. We need to think about what can we do to make their life easier and support them and consider their freedoms as well. So that's part of it as well. So these are the 5 main principles that underpin, and it's really important that we consider these throughout. And just to make sure everyone is on mute if you're not speaking, just because sometimes we get some feedback as well, if that's okay. So here's where we get everybody to get involved. So if I can just ask, oh, sorry, one sec. From current slide. So what types of decisions might we assess a person's capacity? So
yeah, Lizzy, you're on mute.
I don't know how that happens, so sorry all.
Just start from what types of decision we missed you from there.
Sorry about that. I'm just going to stop sharing for a second. So I'll just come to the wider group because then I can see everyone. So what are some of the decisions that we might consider under a Mental Capacity Act? If I can ask everyone to pop in the chat. Okay, so we've got managing finances, or pop your hand up if if you're feeling brave. Great, so we've got finances, having equipment or adaptations, yep. Where to live, serious medical treatment, yep. Care and support needs, accept or declining support, yep, that's great. Increasing the current package of care, medication, these are all great. Marriage, so significant chance, so social needs, sexual relationships.
Why am I not?
Living arrangements have, okay, and relinquishing tenancy. These are all great. So I'll share again, and we can talk a little bit about that. So, these are some of the decisions that we might consider categories. So healthcare and treatment decisions. So we've got that, and we've got relationship decisions. There are also some legal decisions, social and welfare decisions, and property decisions. So some of these are some of the ones that may end up perhaps in the court protection if we have to go that far. But at the moment, these are, and what I've done is broken some of these down into different categories, so you can see some of the things that we might consider within this. So healthcare and treatment decisions, some of the ones that we might consider are admission to hospital, consent to treatment for a mental disorder, consent to treatment for a physical disorder, contraception, a cesarean section, perhaps, or a termination of a pregnancy, or a transfer within you know, a facility, for instance. But so these are some of the things that have previously gone to perhaps to the court of protection and fall within those treatment decisions. There are smaller decisions that are within that which aren't. So for instance, you can withdraw blood from someone without having to do a full mental capacity assessment. But what we would expect is for everyone to check in and get that consent and understand that they understand what is happening as part of that. An MCA can be done at a smaller level to check in around that, and that's what we wanted to talk about a bit more today. So relationship decisions. So You can you can do an MCA around contact, you can do an MCA around social media and internet, and then also consent to sex and understand sex. However, and also around consent to marry, as well as separation, divorce. However, we can't ever be involved in the decision on who someone chooses or whether they, you know, if they can have sex. It's about whether they understand consent around that. So it's really not about any one person. We can never dictate what people's decisions are around it. What we can do is look at their decision making and whether they understand risks or understand things around sexual relationships and how they do that. So that's something that we do look at. And then legal decisions, so things that have also been considered as part of legal decisions, is appealing detention. So detention to it might be that detained under an act, but often the Mental Health Act has its own process. But it might be that if someone has been detained, for instance, whether someone has been detained by the police, it might be that we need to support if they don't understand what has happened. So litigate to defend an action, give evidence, fitness to be interviewed by the police. So sometimes it might be that someone is not able to understand being interviewed by the police or to stand trial. Often we get understanding around tenancies as well, and legal decisions around that. And that's something that we might have to look at in terms of, can someone sign a legal document? Can they understand? And can they understand around those decisions? And sometimes a mental capacity assessment may be required for that. Okay.
Lizzy, we got something in the chat.
Yeah, sure.
And someone just wanted to know, is the right not to resuscitated, is the right not to be resuscitated included in this criteria?
It is, yeah. And some of you may know that during there was some controversy where perhaps there was some do not resuscitate orders that were completed during lockdown, perhaps without the formal process. But a doctor should be and should always make sure that that they understand that of a DNAR. And if someone doesn't have capacity to understand it, they need to be doing that as part of best interests and understand a clear process for completing that do not resuscitate order. So it should be done alongside a family member. They should help sign it if they can't, and or the person themselves if they feel that they do have capacity to do that. And sometimes perhaps it isn't really clearly recorded, and we need to make sure that we are asking people to do a full capacity assessment, because what we don't want to see is that someone is completing a DNAR or signing one on behalf of themselves when they actually don't understand, or they might be perhaps under anesthesia, or they might be affected and they don't fully understand it, or they don't have support to understand it. A do not resuscitate order is quite a complex thing from my understanding. Obviously, I'm not a medical professional, but it is about what steps someone can take to resuscitate you, which some of it might be detailed about what they can and can't do within that process and steps they can take. So it should be that that doctor has really gone through that process of helping them to understand what that might be. So yeah, just to say, and yeah, if anybody does feel that something hasn't been filled in properly, then that can be appeal with the doctor and make sure they've documented it properly. So thanks for that question, and any more questions, do let me know. So just
and
to
also, was marriage covered?
So marriage is consent to marry is important. So sometimes it might be that we feel someone has under duress or doesn't understand what marriage is or a relationship. It's quite a low threshold, because often people can say clearly, I want to be with him, I love him, I would love that support. So it's quite a low threshold for saying I understand what a relationship is and I understand I can consent to it. And marriage, what that means, people do often understand what marriage is. I think it's just sometimes it might be that we have a worry that someone doesn't understand what marriage is, and they might be doing it from influence from someone, and we have had cases like that before. So it's really important with marriage, but we can't ever say who someone can or cannot marry. That is not a best interest decision. But what it is, it's about the decision to consent. Do they know what marriage is? Can they understand it? Can they decide to get married? Do they understand what a legal process is around marriage? And that's the decision that someone might test. And often it might be that we would expect a registrar to do that test and to check with someone if they understand. And often they will meet with a couple or meet with someone to check whether they understand that. And if they have any concerns, because we have actually checked in with the registrar's office, they may refer it to someone if they don't feel that someone understood that. And I know there was someone who had dementia. There was actually a concern around abuse. They'd tried to go to different registrars, and that person did not consent because the person presented with dementia and did not seem to understand the person or who they were. So that was then referred to the police. So it is around really testing that and understanding that they can consent. So the law is mostly used by professionals. Important decisions relating to someone's care or living arrangements, medical treatment or money, and need to be made. The law allows us to plan ahead for time when we are unable to make decisions for ourselves. Okay, now, so just to be clear as well, one moment. Oh, I've got Alice. Have you got your hand up? Alice?
I was talking about it before, because when things like medical and health, I always prefer not to get involved, because I do not have enough information to be able to give to the person to make that decision. So what do you say about that? Because you talked about cesarean, termination, admission to hospital.
Yeah.
So what do we do with that? Because we do not have enough knowledge to be giving the information they need to make a decision.
I mean, if it's anything like that around contraception or any treatment, it should be a medical professional. And obviously, we need to make sure they've been provided with enough information, they've been provided with enough discussion around that to test. And sometimes it might be that, you need to see someone, talk about the medical process and help them to understand. And then later you would come back and you would test that and you would check. Because sometimes you need to provide the information to someone, make sure that they understand it, they've retained it, they've weighed it up, and then you can test that. Some people may not know anything about medical processes, and it might be that you have to return to that. But it should be that the right person is the one that does the assessment and does the decision. So with anything like a termination or decisions around their medical care, I would expect a medical professional to lead on that, which is very good because we are leading now into who is the right decision maker and who supports. So that's the next section, really, because I think what we often get throughout the process is that we might be referred to make a decision, and often people think that social services or a social worker needs to make that decision, but sometimes it might be that an occupational therapist might need to make a decision, or it might be that a care home manager might have to make the decision, or it could be that a doctor needs to make the decision. And sometimes if it's a legal process, it might be that a solicitor needs to make the mental capacity assessment, because they know about the legal process and they can look at that and understand it if it's more detailed. So we just need to look at those decisions, and it's about the person doing the mental capacity assessment who is best placed to do it. So if the person's decision is not it is helpful to phrase this. So we've got the decision has to be phrased first of all from the person's point of view, and so as well, it should be, what should my care arrangements be, for instance, or should I have a recommended medication? So it could be a pharmacist, and how do I want to receive this? So we shouldn't be writing he is not safe on his own and be writing it from the perspective that it's something that's happening to someone. It needs to be done from their own perspective. And should Mr. Jones receive the necessary medication treatment? No, it should be that they, how do I want to receive my treatment? And we should be rephrasing this assessment to go from their own perspective. So, so that's identifying the decision. Second. There we go. Can you see this
Richard
now?
has a question. Sorry, Lizzie. Richard has a question.
Sure.
I only managed to do, didn't I, a short period of half an hour before I spoke.
Well done.
It was just a reflection on that kind of conundrum around who's the best person vis-a-vis kind of healthcare. So I was just trying to put it in the chat. So the local authority is not the responsible body for the delivery of healthcare, nor is it legally entitled to deliver healthcare, except in certain prescribed circumstances. and there's various case law that backs that up. This came to light during kind of COVID vaccine rollouts when we were trying to make decisions around that. And initially, we had a lot of medical practitioners coming to us to saying, "Can you do a mental capacity assessment, please, on person X, person Y, about their ability to have or accept or give consent to having the vaccine?" And we're all slightly surprised when we said, "No, sorry, we can't."
No, exactly.
We can help if we're involved with the person and we know them, and we might be able to facilitate the conversation, but we are not the decision maker. So it's so anyway, I just thought that was an interesting example.
Thank you. Yeah, and we have another example here which I just want to get everyone's opinion on as well, so thank you, Richard. So I'll see what people's view is. So if you can pop it into the chat. So Mr. A has dementia and limited mobility. He sometimes refuses care and support and has started to struggle with moving himself in bed, so he can't turn himself over. And this is leading to a need for pressure care and support in his care plan. So carers are needed to go out and turn him and support him. District nurses have had to come and see Mr. A for a grade 2 pressure sore. So this is where the skin has broken down, started to break on his lower back, or sacrum as it's known. He is refusing carers and nursing support. So can I ask, who should be completing a mental capacity assessment? I'll get Jenny, because I don't want to come out or other people will see the answers. So I'll get you to tell me what people are saying. So who should be completing a mental capacity assessment for this gentleman?
District nurses.
Right, so we've got district nurse.
Yeah.
Yeah, a lot of people are saying district nurses.
Okay.
District nurse or social worker. District nurse for nursing decisions, care in bed.
Okay. Okay, no, that's really great.
Yeah, district nurses or the GPs. And finally, social care for POC and DN for pressure care. 2 decisions.
Okay, well,
thank you, Laura.
Thank you, Laura. So there are different levels of decisions. So what we would see is that we've got care and support. I would say that if Mr. A is refusing care and support, and it's the care package, which is commissioned by the care local authority, is that consented care and support, and to say I don't want the carers, would be for the social worker or the local authority, maybe an assessor, to come out and see. They would decide if they needed any care and support, and it would be needed, and whether we might need to do that in their best interest and put that care and support in. Therefore, they might be the decision maker. However, when it comes to refusal of medical treatment, so that is perhaps the dressings, it might be that someone needs to give him pain management to manage the pain in his back, things like that. We would then, it's a bit of a trick question, the fact that there are 2 elements to this. So we have to break these decisions down, because to refuse the carer's entry or to refuse to allow them to move him in bed is the care and support. However, the refusal of the medical treatment and the pressure care, so for instance, it might be that district nurses need to put some equipment in, and that which is a particular mattress to reduce the risk. And if he says no to that, that's a prescribed thing that they are providing. And it's the same with regard to maybe perhaps medications, and it's also with that wound management. So I would expect the GP or the nurse to do that consent part and look at, does he really understand that he could get an infection? Does he understand that it will break down more? Does he understand that this could get worse? And actually, sometimes infections can lead to a blood infection, and people can pass away from having a really serious infection to their skin. So someone has to really understand how to explain that to someone, and they have to understand what are the long-term risks of that. And to test that, you need a medical background for that. Whereas consent to care and support and refusal of that, we would need to know that we are the decision makers who would continue to put that care and support in, perhaps in that person's best interest, if they don't understand. But that might be dependent on the level of restriction on the person, and there would be lots of different steps to that. But that would be for us to do that part. So it's just to break that down, that there sometimes are 2 elements to that will be required. and we need to look at that and maybe risk of around refusal. So the decision maker is usually the best person best placed to make the decision. So change of accommodation and discharge plan. So, and a likely decision maker. So we've got medical investigation or treatment, daily care, managing risk to self or finances. Now I won't. I'll just go through, but it would be. Let me just. So, change of accommodation and discharge care plan. I think it's just to be aware that sometimes it might be a health or a social care professional with regard to that. It could be that someone is funded by the CC, not the ICG. I'm going right back, the ICB, and we need to think about what it is that who it is that funds them, and if it is that they are fully funded by for instance, Continuum Healthcare, or they are maybe privately funded via, and then they have someone that supports them separately. It might be that we put them via health or social care, and they might have more health-based support, and they might need someone to look at perhaps having accommodation or support that is more health-based, or if it is perhaps social care who are funding that and it is about that. Or it might be that we look at a healthcare professional looking at their discharge if they need some healthcare support. So sometimes it can be done by both, sometimes it's done by a single person. Often it might be the person who's commissioning the support that might look at that. A medical investigation or treatment would be a medical professional. Daily care, it could be a nurse, it could be a therapist, it could be a care worker. So there is different levels of that, and we'll talk about that in a moment. And then managing risks to self. So this can be a number of different people, which could be the police. It could be that they have to make that initial decision that they don't understand, and they might have to be taken to a place of safety. A housing worker might have to do that. Sometimes we have supported housing who might have to determine there's a risk to themselves that you can determine straight away, or perhaps a social worker. And then finally, it is finances, which could be a funding body, such as a local authority. Oh, sorry, it's a CCG, but it should be ICB, and apologies for that. That's an older slide. So, go to the next slide, hold on. So, just go back one. So it was just to remember that if the person has a relevant lasting power of attorney or deputyship, then the LPA or deputy will be likely the decision maker. So it's just to say that if they lack capacity, there might be a legal, perhaps a legal representative who will support them, which we can come to in a little bit. Okay, so please name. So the decision maker is usually the person best placed to make the decision. But these decisions can be small decisions, such as decisions about daily care and treatment. So I was just wondering if people could just pop in the chat, and if you're able to say what people are putting, Jenny, if you can please name some small decisions that you think you need to check capacity and understanding on a daily basis. So it might be in a care home, it might be in daily care that you do and support. What are some of the things that you would want to check around whether people understand what you're going to be doing? If people can pop that into the chat.
Okay, so we've got refusal of care.
Yeah.
Assessing community. Personal care. What to eat.
Yeah.
And we have a hand up. Who's that? RDN.
RDN.
You're on mute, RDN. We
Can
have
you hear
managing
me? Hi,
finance.
sorry. Okay, just a quick question, Lizzy. When
Yeah.
the person has got like a deputyship, or someone else basically has been issued with lasting part LPA, lasting part of attorney, what would be like the default position as a starting point for us? My understanding is that the MCA, it is mandatory whether or not the LPA is recognized, but I'm not clear. So I need some clarification
I think
around
it's
that.
really important to know that we would still expect anybody who is acting on behalf of someone, like a deputy or a lasting power of attorney, they still need to be acting in their best interests. So they still need to be using the options available. And, you know, if we did see that someone wasn't making appropriate best interest decisions, it might be that we need to go to the governing body to talk to them about that if we feel they should be. So, for instance, if there is medical professionals who are providing 2 or 3 options, or 1 option or 2, they can't just decide what medical decision to make for them. It would be that they would be provided with the best interest options, and they would need to make one of those. Is that what you meant, Ardian? Sorry.
No, shall we let this run its course, this sort of process? Or, for example, say in the situation when there is a change of the accommodation is required, say, for example, person needs to move into residential home, is then the MCA like a sort of starting position, or the person they live with, like i.e. their family or their carer, etc., they have already taken this decision on their behalf? I'm not so clear.
I mean, so the lasting power of attorney and deputyship should only be applied when someone has formally lost capacity. And sometimes that might fluctuate for someone. And it can't be, because sometimes I find, you know, there is someone who maybe have early stages of dementia, and they actually can make many decisions themselves. And on a good day, they are able to make decisions about many things, including their own finances. When we've gone to see them, we've done a mental capacity assessment, and actually we found that they can manage their own finances at this current time, because it's time specific and it's decision specific. That might change 3 weeks later, but at that current time, we've assessed them as having that capacity. And I think what happens is some people say, oh, I'm lasting power of attorney, I'm deputy. I mean, deputy, you have to have lost capacity, but with lasting power of attorney, you can appoint someone ahead of time. And I think that's the thing. Some people say, I need to make decisions for this person. It might be they say, I would like their support to make that decision, and they might give consent for them to, or they might take their support and make that decision with them. But if they actually have capacity and it's not in line with what they say, then the lasting power of attorney does not apply. They have to have, and so we must do a formal mental capacity assessment. And if we aren't sure whether they do or don't, we have to repeat it. So at that time and day, and sometimes it might be that there's disagreement. We might need to get someone else to do it as well, just to confirm.
Thank you.
So
yes,
thanks,
that answered my question. Thank you.
Thank you, no problem. Sorry, just to come back to this question. So just in the chat, so thank you for all of your answers. That's really helpful. So some small decisions that you need to think about. So I think it's just being aware that, you know, the daily support that you provide, we need to really show that we're looking at people's understanding and their ability to consent to different things on a daily basis. And these are, you know, more simple decisions. So the small examples of checking, so for instance, you can do a blood test without a formal mental capacity assessment, but we'd want to see on the medical notes that we are looking at that. Personal care, you know, we need to be checking. It's quite an intimate thing to be going in and to be supporting someone through every step of the way, through changing their pad, through moving them in bed, through helping them change. We need to just check that they understand what's going on and they are in agreement. Taking part in an activity, some days yes, some days no, it might be the case. But is that affecting them? Do they understand? Accepting or refusing food, you know, do they understand? And is that part of lots of refusals? Do we know if they understand they might not be getting food a bit later? Do they have access to other food? So we'll look at that as well. And consent to speak to a family member or share information. We need to be checking in around that, if they understand that and know if they understand why. And because sometimes people say, I don't want them to know anything about it, but actually it might be that they don't understand why we need to share that information. So we just need to check in with them, and also around taking medications as well. So sometimes that's a daily thing, and we need to maybe revisit it and discuss. So I'm just going to pass. Oh,
sorry, Lizzie, we have a hand up from Michael.
Oh, yeah, sure.
Michael.
Hello. I
Michael.
thought it was the health and care one that can't be used until someone's lost capacity, but the finances one can be if the donor wishes it. So I think it's
if the donor wishes it, yes. So
yeah, so I think it's very important
so
to
it can be
make that
done alongside them with finances. Sorry, yeah, if I wasn't clear.
Yeah, so if a social
the
worker
health
is
and
dealing
social
with
care, yeah,
where someone lives, I think it's it's the second one, isn't it? So it's the
Yeah, no, you're right. Sorry if I wasn't clear on that. We haven't got to that bit yet just as much, but it is true that you can ask for support from the financial, they can act on your behalf if you give them consent. I think what we just don't want to see is on those occasions when someone they do have capacity, and sometimes we can see that LPAs perhaps have, maybe used some people's finances inappropriately. And that can sometimes happen as part of the process. So we just need to make people clear sometimes with family members when that comes into effect. And so it's just really, really important. I
We have
see another hand up.
there.
Amy, is it Amy? Amy?
You're on mute, Amy. Maybe not.
Can you hear me?
Yes, we
Hi,
can.
Amy.
Oh,
Okay.
sorry, I didn't know if you meant me or not. Sorry. What was the question?
Oh, I just saw your hand was up.
Oh, that's probably no. Sorry, that was done by accident.
Don't worry, no problem. Absolutely no problem at all. I'm just going to hand over now because I know. Sorry, Rachel and Sylvia. I know you weren't here before. I did try and introduce you, so I just want to introduce you now. If you want to introduce yourselves, because I'm just coming up to your slides. So just want to welcome Rachel and Sylvia, who work with one of our care homes in our MCA subgroup. Rachel.
Good morning. Good morning. My name is Rachel. I'm the Service Improvement Manager for Fairley Healthcare Group. And I'm Sylvia Onyekulu. I'm the Centre Director here at Fairley House.
Great. I'm going to just share this now. 1 second. I just wanted to come off while we say hello. 1 second. Here we go. And from current slide, can you see that? Is that right?
Yes. Yeah. Good. That's lovely. Okay, so this is a very interesting case that we had and caused us a bit of angst. Mrs. X is reliant on total perennial nutrition, TPN, for all her nutritional needs and her abdomen open due to significant gastro complications. She manages the wound with assistance inside the care home. She is aware of the recommendations, the specialists of consuming free fluids and impact on her skin, how it impacts on her skin integrity and food not absorbed. Regular takeaways is what she likes to do. Drinks and food.
So are we asking everyone what will they do in this situation?
Yeah.
What they want to see?
Yeah. Correct. So let's go back to the group first, just to see in terms of consideration. So this was a dilemma for the clinical team or the care team on a daily basis, where they see a member or a resident putting themselves at risk, in essence, and the complication in terms of the wound deteriorates over time and so on. So going back in some of our sessions, so we do induction MCA plus also monthly sessions. And this was brought to one of our MCA training, and the staff wanted to discuss how to handle this without depriving the lady who has capacity, in essence. And we wanted to demonstrate this using the Principle 3 of the Mental Capacity Act. Next slide. Okay. Then we'll go to the rest of the team.
Yeah, sure. So this is what I had, is that right? Yeah.
Yeah. So some of the things we had to do is initiate a meeting in the first instance to support Mrs. X in making that particular decision around her care and treatment. And this was making sure that her significant orders were available. So her sister supports her on a day-to-day basis. So we made contact with her, but never spoke to her separately. So to make sure that she had that support always. Making time to listen was very important so that we can hear her voice and what she wanted for herself. And also in terms of her delivery of care and making sure the support care plan reflects her personal wishes, and that the staff understand that she wants to take those risks and how we can monitor those risks in terms of the process itself. So some of the challenges for us was around the monitoring of those risks. So we wanted a second opinion. So we did go to Safeguarding in terms of this to escalate to all the professionals to see what their views were around this whole Mental Capacity Act 3 of unwise decision making, and what's because the staff were very concerned about that they were putting her at risk in terms of neglecting her, not giving her the right decision. She was able to make her own orders, so the food will appear on the premises. With a delivery note, and she also sometimes used somebody else's name to deliver this food. So some of this was around. So we wanted to monitor what she eats so that she can see it. So we took some photograph of the food delivery, which actually made her see the amount of food she orders at a particular time. And that helped her to make that decision in terms of saying, okay, yes, I want to eat takeaway, but can I make that smaller? So we're looking at the balancing the risk as well.
I remember there was a part where she actually was allowed to taste, wasn't she?
Correct.
She was allowed to taste food, but not, as you can imagine, when a delivery comes, it's like packages.
So again, I think just taking a picture of what was delivered made a whole sense, because to her, she was ordering a takeaway just like any one of us, you know, on a Friday night, you order
your curry.
And my favorite is Chinese, by the way, anyway. But
noted.
you don't know how much you order until until the food has arrived. So it was a really good element to include a picture of what delivery, so that she can appreciate size and context the amount as well. Again, the care plan must reflect those principles. So in essence, to identify that this is unwise decision. Yes, she can make it, but is this proportional to the harm she brings her way, and so on. So these are some of the things we did within our service. So any questions we could take? Thank you.
Any questions on that case? Or what you might have done differently? It was a really good example, and thanks, Rachel, for that, because I think sometimes it might be, and it could be that actually because sometimes we have it maybe with people who are diabetic who might get ill over time, and you would continue to check that. Greg, have you got any thoughts on that?
Sorry folks, hi, I'm kind of interested in the support plan side of it and wondering what kind of time was allowed for the care calls, given that's always a pressure from a local authority point of view, you know, when we're saying we've got to spend time talking them through, listening to their voice, etc., that implies funding pressure, and you know, it's sometimes a difficult thing for us to to grapple with.
Absolutely, Greg, and I think, sorry, Rachel, I know that this was in a care home, wasn't it? Wasn't?
Yeah, but even in our setting, one of the things that I always say is, if you make time in the first instance, you eliminate some of the challenges on a daily basis, because for the care staff, every time she ordered a takeaway, they were heightened. So just having that, I think we had about three meetings with her and her sister to just look at it in context of what she was trying to. So it was time invested to get to her day-to-day care, in essence.
No, thank you. No, that's a really good point, and I think it is about thinking about that. And also sometimes things may change, you know, if someone does expose themselves to maybe risk, and actually by you know, for instance, like I said before about maybe people who are diabetic, or they may lose some capacity over time if they continue to expose themselves to physical health needs, that and actually it's part of the process. So you might have to revisit and test it again, and I'm sure that you might have had to do that before. Was there any other questions?
Yes, Pamela, would you like to come in?
I've got a question. I just wanted to know with Mrs. X whether she had an impairment of her brain or mind, or whether she was making an unwise decision.
So she had capacity, in essence. A bit of depression, but not excessive that you say she's cognitively impaired. Unfortunately, she has a terminal condition, And thus what we had to consider again is around what is in her interest, because specialist help will say
I think that's one of the things.
Just to say, the terminal condition wasn't going to be quick. This lady was going to be with us and has been with us for years.
Yeah. But I was just going to say that's one of the things that I have difficulties with deciding. You know, she has clearly got capacity and she is aware of the risk about pressure sore. She wants to have takeouts on a Friday night. Whether or not I would do an MCA in that case, because she's, you know, we know clearly that she understands the risks. So I think that's one of the things that I grapple with, you know, because you know there's no reason, underlying mental health reason why she's making that decision. It's a choice.
I mean, I feel like that a lot of it is about the underlying principles of the Act that can be incorporated into care and support before we get to that point. And I think it is about just thinking about how we can check in around people's consent and understanding, sometimes before a formal assessment, like you've done, Rachel, before it gets there, because you are checking and monitoring, aren't you, as part of that?
Yeah.
Right, we have some hands up now. Would you like to come in? You're next, Michael. You're on mute.
I was just thinking it's best to perhaps, you know, if you're doing a risk assessment with the clinical issues, to get expert medical guidance to base the risk assessment on. And also, she may not have mental capacity, but she may have clinical depression, you know, and there may be a medicalized reason why she's, you know, doing something that's overtly risky. So I think putting it to safeguarding is one thing, but I think getting an expert medical opinion might be another thing to do.
Yeah, just to say she definitely had some input from the stomach nurse specialist, dietitian, because she was under the care of the dietitian for TPN. They were concerned that this will impact on her well-being and so on. So there were quite a lot, and then obviously the GP was involved in the final meeting to look at what are the risks and benefits in terms of her day-to-day management.
Thank you. Stephen.
And there's a question that says, did the picture help? Yes, it's actually reduced the amount. So where she ordered 7 cans of Coke, she then went down to 3 and 4, and so on. So, you know, just seeing the volume was key to it.
That's good.
I just wanted to say these are they're very interesting examples, this one and the other guy before with dementia. I guess they're both cases where sort of conflict has arisen. You know, that we're sort of talking about these as an example where we are looking at the MCA because something is happening which we're concerned about. And I suppose wanted to just check and raise really that we'd be considering MCA anyway, like for instance with the guy with dementia, if you know, this came about because he was refusing to be moved in bed. Well, even if he was not refusing to be moved in bed, this would still be a consideration for MCA, wouldn't it? And would we be doing anything different in terms of well, district nurse or whoever doing anything different in terms of their use of the MCA to look for a way for, you know, to best interest decision about this? And in this case, maybe in the same way that, you know, although you're saying that she's got capacity, presumably something around the original kind of TPN intervention, there would have been some consideration around what she needed. And it was it was just to say that we need to be thinking of MCA for all the other cases where there isn't conflict.
Yeah, no, absolutely. Yeah, I would agree. Would you agree, Rachel? Sometimes it's it's all of them, isn't it?
Yes. Thank you. And then finally, we have a question from Laura.
It's more, I want to share an example. I was a support worker in extra care housing for a few years, and we had a lady who had dementia, very advanced dementia. Her communication was very limited, and she hated having showers. She hated them. So what we did is we will always be the same to people doing her showers because she was very familiar with us. And we will gradually introduce her to the shower, and we will be like explaining, this is what is going to happen. And eventually she will consent. Just when we explain, we're going to do it very quickly. So we had a plan. It was all done very fast. So she didn't have to be under the shower for a long time. And yeah, so it's just kind of like, we didn't do a capacity assessment. We were support workers, but we did kind of assess her ability to consent and made the best interest decision at that time.
Exactly. And I think that's the core of it, Laura, is just that we make these assessments and these best interest decisions in small ways every day, and that we need to consider this act as part of it, really. Yeah. So that's a really good example. Thank you. Was there anyone else? Or I was going to move on. Is that all right? So thank you, Sylvia and Rachel. Really good, interesting case and really, really useful. And just to say that, we have our mental capacity subgroup, which sits part of the board. I sit as part of the board as well, and with our head of service and other professionals, which includes the care homes, police, fire brigade, and all our health partners. So it's really useful to hear sometimes that how we support at all levels in daily care as well, and how we assess capacity, because sometimes there can be very complex cases within our care homes as well. So next was just to talk about assessment of capacity, and it's just to be really clear that really this is something that you're doing on a daily basis. Capacity assessments are a conversation between the person and decision maker. Obviously, sometimes there are more detailed assessments where we might have to prepare some questions, make sure that we're thinking about what do they need to understand. If it's a very complex case, we might have to think, right, what do I need them to know that they understand before I go there? And you might prepare lots of things, you might do a number of visits, whereas smaller things at different levels might be a small thing. Do they understand that I'm just going to move them over here? Do they understand that I'm going to wash them there? And it's smaller. But with regard to decisions where it's a bit more of a detail, we need to make sure that we've taken all practical steps to facilitating the conversation so the person has the best opportunity to make the decision by themselves. We need to be ensuring that that is possible. The conversation should commence with the decision maker outlining the important factors of the decision. So we need to tell them that we're going to be checking in around it. We need to know that they, and that we want to know that if they can understand the information, can they retain it, can they weigh it, and can they communicate it? So those factors in the overall decision. So if the person is unable to understand, retain, weigh, and communicate factors related to that decision, and we're going to come on to that in a second, and the reason for this is directly linked to their impairment of mind, then the person was deemed to have not to have mental capacity around that decision. So it's just to be really clear that that has to be evidenced clearly in our assessment. And sometimes, we might look at an assessment and we might say there's not quite enough here. We need to really put part, because sometimes it might be that needs to go to court, and we need to make sure that therefore we have this really robust assessment that says, so that's why when I say it at all levels, some things will be more minimal and it will be more simplistic decisions, and some things will be, these really complex ones which we'll have to take forward. So this is just a tool that we had, which is just the 5 stages, and it's part of something we developed in the MCA. So we just need to make sure that with the presumption of capacity, we start by thinking, I can make a decision. And then 2, we need to take realistic steps to help me make a decision. So we need to think about the person. I'm unwise decisions. Just because I'm making an unwise decision, it doesn't mean I lack capacity. 4 is my best interests. Any decision made must be my best interest. And 5, is there a less restrictive option? So this is all the principles incorporated, but just need to think about it from the perspective of the person. And it's about no decision about someone without that person. And that's really the core of what we do with our safeguarding board. So next, I just wanted to talk about supported decision making versus dependent capacity. It's just to say that when we say within the Act, it's really important to think about how we help people to make decisions. So retaining and weighing up information and expressing a decision depends on what they understand about the information in the first place. So for instance, if we think about someone who maybe has had a mum who supported them, they have a learning disability, and they've maybe been supported to manage their finances by a parent for the whole of their teens. They are moving into a supported living accommodation, and then suddenly we're saying we're going to come and do an assessment on their capacity to manage their finances. Now, if we haven't provided them with an understanding around money and finances and how to manage a budget, how can we test their ability to manage finances? So what we need to think about is, have we provided them with all the information to do that test? So for instance, what we might do is ask that accommodation to provide some money to that person over a few weeks to help them to follow a budget and see if they can understand how to look after money, what they understand about their bills. But if their mum or parent hasn't passed some of that over to them or supported them to do that, we need to be helping them around that. So that's just one example. And it might be also that we need to provide them with pictorial tools or different things to help them to understand. They might need an interpreter. So we just need to think about how have we supported them to help them to make that decision, and if they need some support to get there. And it might be that they need a familiar place or person with them. It might be that they don't feel comfortable sometimes speaking to the person who's come out to see them. You might need to build a relationship with someone. So it's just being really clear that supporting an individual is different from an individual being dependent on another person. And often we might get an MCA where do an assessment, and we might have a family or friend who are talking over someone, and they're saying, oh, I make that decision for them. But actually, if we give them some space, some time, they might be able to make that decision. So we need to make sure, is it that they are being supported, or is it that they are dependent on that person? And that's really important. So this means the individual can independently weigh up the quality of the information provided and determine what it is, whether it is sufficient or not. And if not, identify what additional information they require to make an informed decision. And then with dependent capacity, it's where this describes an individual who is reliant on others to be able to make an informed decision relating to the specific decision in question. Without this support, they're unable to make the decision, because weighing up and applying the information is not able, they're not able to do that by themselves. They have to have someone to help them, and they're not able to really understand it at all without that person. So that's why we would see that. So it's just to explain the difference between the two. So, and it's also just to think about when we do planning, you know, like we said with finances, what would we want them to understand? You know, what is money? You know, concept around that finances. Where does it come from? How they got that? What are their benefits? How do they get their money? How do you invest it? What are the practicalities of managing money? So these are all the parts that you would hope that they would be provided with the information. What they might cover in their day-to-day budgeting in the short term. What do they need to know? What is your income? Do you have any regular outgoings? So that's short term. Long term, for instance, it might be, for instance, some people maybe who have a home or who have a mortgage, for instance, we might have to do a test on their capacity. How would you make your compensation payment, or how would you identify something as an investment or long-term medical needs you might need to pay for? So things like that. And that's a longer-term medical financial decision. So we just need to think about all these different concepts and levels of understanding when we're doing the test. So I'm just going to do an example here now. So, and I'll put this out to everyone, if you can either put in the chat, or if you can put your hand up if you want. So there is a young man with an intellectual disability. He's used social media to share images and videos of his genitals with an unknown man, and searched compulsively for pornography, or which some of it which was illegal. So what would you expect them to understand about the process when you're going out to see them? So what do you think they need to know about social media? So this was actually a case that went to the Court of Protection, and we need to know, what would we want to see in that mental capacity assessment as an understanding to know whether they understand about sharing that information? What would we need to see? So what are some of the questions you might ask? What are some of the things you would want to know that they understood about sharing images and online use? Oh, back.
Right. Private and public sharing, and also the risk to themselves. Yep. Do they understand the public nature of anything posted to social media? Yep. Someone's asking, does he understand consent? There's the legal element of it as well.
Yep, absolutely.
And just a full understanding of social media and what it actually entails.
Yeah. These are really good. Sorry, yeah.
So it's me, it's Malvina. I guess this was hello, hi everyone. Same as what the last person said, and just around like the consequences. That once he's shared that, he loses all control over what happens to those images, and they could end up anywhere. Literally.
Yeah, no, that's really, really important, and consent is a really important part. You know, sometimes it's a concept that maybe putting it out into the world, that do they understand what will happen to that after? That's a really good point. Yeah, yeah. Thank you. Was there any other hands I can't see? Sorry.
No.
No. Okay. Yeah. So just to say, these are really good points and really good. So he will need to understand shared images can be shared more widely. So the possibility of using privacy and location settings, does he know how to do that on his computer? The risk of causing upset or offence when placing images on social media sites. So he might not realise that that will be that can cause upset and offence, and how some other people may feel by that. Sometimes that people you meet online may not be the people who they say they are. So does he understand that actually that person might not be who they say they are? People you meet online may pose a risk. They might lie, they might cause harm to you, or they might take advantage of you. So that is also something you would, and also it's their understanding around sharing some images or messages may be a crime, and what those images are and how that will impact them. So it's just really complicated, but it was just like what they needed to see that there was understanding of, and that was set within this case and a bit of a precedent. So it's just to show that with these more complex assessments, there are so many elements you need to show to really prove that someone understands what they're doing within that. And that's something you would need to demonstrate within your conversation. So we're going to just briefly touch on the best interest decisions, which happens after obviously the mental capacity assessment. But I just want to say that obviously there is a session tomorrow from 2 o'clock, which myself and Marla will be presenting. Marla, who's head of safeguarding at Guy's and St Thomas's, she'll be providing an example around health and health, because she's working in works in the hospital, and I'll be looking at social care and how we look at the checklist. But just to say that there must be considered, so the best interest checklist outlines what must be considered when making a decision in a person's best interest. So it's good practice to consider the person's present and past wishes. It's important to think about their feelings, values and beliefs at the heart of any best interest decision. So it can be complicated situations can sometimes arise where capacity is not clear, or best interest decisions need to be made about a variety of decisions. So these situations could involve a decision maker from different agencies, and it's about so we just need to think about all of these things when we're looking at best interest, and then there'll be steps that we need to take and look at the pros and cons within that, and a checklist of what is the benefits and what are the cons around that. And it's also to be really clear that best interest decisions about family relationships are not covered, so who you can choose to have a relationship with and may require jurisdiction of appropriate by court. So okay, oh sorry, one back. So we're just coming to the end. So recording. So the final thing I just wanted to make clear, because obviously this is about recording at all levels, and I know that some people here work in care settings, some people are social workers who may do it within, we have a form and we fill that in as part of adult social care, and it's quite clearly stated. But if we're actually just doing small check-ins at different levels, it's just important about how we record that information. So for example, Mr. B is refusing his food at dinner time. It's important not just to state he's refused, but to be clear why. What does he need to understand about that? Has he already eaten, or is it due to confusion? So for instance, it might be that he has started to get more confused. He's got a UTI perhaps. Does he know that he can have food later? Can he access that food later? Or will it be that he doesn't understand? If we can see that someone is deteriorating, or there's food that hasn't been had or eaten, we can see a pattern and we can see whether they understand. But if someone refuses food and we need to understand why, and you know, it's important that we know why. It could be they just don't like what's for dinner that day, and that's absolutely fine. And they've got snacks by them, no problem. But we just need to know in the notes that it's clearly recorded as a pattern, and his understanding and capacity on going without food. And it's really important to record consent and the views of the person clearly. and even when someone is in a care home and under deprivation of liberty. So we sometimes have orders in place to say that we can provide restrictions on that person, but it doesn't mean that daily decisions are not. It's important to check in around all of these things, make sure care is done with people's consent and support, and important to check in and record decision daily and how you're supporting and checking consent on different things. So that was it really today. I just wanted to, for this session, but I wanted to take some questions if anyone has any around this, but it was really just to say that we need to think about mental capacity at all levels, with simple, intermediate and more complex decisions, and recording is an essential part of that. I'm going to stop sharing now, but there is some resources that I put at the end. I know that, hold on. We've got about 15 minutes left, and I just wanted to see if there was anything from what we've discussed today, if anyone has any questions or any cases or case examples they want to talk about. I think we just have done a bit of a whistle-stop tour, but what mainly today was about assessment and how you think about it in all levels. Sharon.
Yeah, it's just to go back to that image of the hand, because when I did social work practice, they always taught an easy way to remember it. So I just thought it might be useful for me to share that. I mean, probably a lot of people know it, but
of course,
but when you do the thumb, it's thumbs up, which means assume capacity. The second one is like the pointing finger, like what have you done about it? Basically, what have you done to help them with the questions, like if the sensory or visual words, things like that. The third one is the middle finger, which we all know. I'm not going to say, but it basically means that I can make unwise decisions. And the fourth finger is the ring finger, which is the marriage finger, which people presume is your best interest at heart. And the little finger is the smallest, so it's the significant, the least restrictive. So I thought I'd just share that.
No, that's really, really useful, Sharon. Thank you for that. And
That I always remember it. It's really easy to remember if you remember it that way.
Yeah, thanks so much, Sharon. That's a really, really great example, and yeah, and a good way of remembering it. I wish we should have had you when I was doing my my social work training when it first came out, and it would have been handy just to remember it like that. But that's really helpful. And I'm going to come to Ardian next.
Lizzy, hi. Yeah, just a quick one about the cases when the test is actually inconclusive. When it's clear cut, I mean, it's the easiest and more straightforward for me. But I quite often find that when you tick a box, yes, in the end, you know, once we've gone through all the assessment and decide yes or no, but sometimes it's a little bit more nuanced than that. Absolutely, I mean, obviously, we go through all the stages like comprehension, evaluation, weighing up the information, you know, all of that. And there is still this, you know, the gray area. And it's more than basically just ticking in a box whether or not the person has the capacity. This is where I struggle with a little bit. So, I mean, it depends, like you said, the how serious the decision, etc., is, the gravity of the outcomes and the implications, etc. But sometimes I just need a little bit more direction and support, I feel personally, around that.
I think, I mean, we should always assume capacity unless you can prove otherwise. And if it is borderline, then, you know, we should be using supervision and support to help us. I've often had to go out with a colleague when it's been really complex to help me to understand someone's capacity, or I've had to revisit a second time. It's really hard because, you know, particularly with the more complicated ones, the idea of removing someone's rights or removing someone's support, you know, ability to make a decision is a big one, you know, and we currently sign off some dolls, and that's even more restrictive if you're saying someone should have deprivation, you know, as well. So I think it's really important, and I you know, we always need to reflect on whether we on balance, but it is on balance, you know, and it could be that that's revisited, someone has to redo it at another point. So yeah, that's all I would say, is that this is about using your professional judgment. And if you do feel that you're not sure, then we can seek a second opinion. We can ask for people to help us with that assessment as well. And you can state, so as Emma said, you can state in your conclusion you are erring on one side or the other, but I'm not 100% sure. It's okay to say that you have reasonable belief, as Michael said. So it is on the balance of probability. And I think that sometimes I can feel uncomfortable if I've made that assessment. It can be hard. But it's just to say that we have to just really go on that. And if you're not sure, then get support. I would always say.
More than one assessment, for example, if you, like you said earlier, the capacity tends to fluctuate. Would it make any sort of, would it be beneficial, you know, for
it can do if someone can read yeah, so it can be like, as Michelle said there, it can be also that, you know, they only need to understand the salient points. So we shouldn't be putting the level that we may need to understand. It's about putting it at the level that someone else and what they need to understand as the salient points of the decision. You know, it's not about understanding every element of it. So I think we might need to revisit it. It might be that fluctuating capacity, because often people with fluctuating capacity, we have to really evidence, and it can be quite hard to take those cases to court, because it might be by the time they get to the court, they present very well, you know, or sometimes we have people who maybe have alcohol or drug misuse and they go into hospital, and then when they come out, or when they've had a few days of being sober, they can suddenly present very well. And it is really challenging, it's just to say. But it is about repeating the assessment over and over, and we need to make sure that we do that, and making sure that we complete that, which I think Richard has just made that point. I'll just come to you quickly, Richard, before I come to you, Stephen.
Sorry, Stephen. Yeah, no, it's exactly that. So on the point, Ardian, it is about escalating, and then your manager's escalating. It's about getting the drawing more people in around the discussion around those complexities. Yeah. So that's your responsibility, I suppose, rather than just holding it yourself. Fluctuating capacity, so particularly around drug and alcohol use, the law is very clear on this. You cannot assess capacity to make long-term decisions while someone's under the influence of drugs or alcohol. It does not apply. So whereas a lot of the world is very worried about somebody who may be drinking, for example, at catastrophic levels, you can't make a decision to remove their inherent decision making when they are not under the influence. So and that's really difficult actually with that, working with that group of people. You can intervene whilst under the influence, but you have to, as soon as they've recovered, you have to redo the capacity assessment, in which case they would fail the first part of the test.
Yeah, and I think what we often see is maybe there might be longer term damage which we have to assess, and it's those where we might see perhaps someone has Korsakoff's, and those are the cases we might take to court, because we can see that there is a long-term damage.
Yeah, because then you have an impairment of mind or brain that's clear and diagnosed.
But again, that can come and go, and it can present differently for each person.
Yeah, depending on how much vitamin B someone has managed to take on at that point in time. But
yeah,
but the point is, it is difficult, and you need to involve lots of people around that group, because it is it's not something I would. It's difficult to feel comfortable doing that on your own.
Yeah, and it was just to say that we've got a session this week, and one is on acquired brain injury, which can include acquired injury to the brain, which may be from alcohol and drug misuse, and that can happen, or it can be from different things that can occur, either
RTA,
yes,
traffic accident.
Yeah, exactly. Yeah, exactly. So we will be looking at that, and then also we have a session on executive functioning, which is going to be around how do you test when someone says something but they don't follow it through, and how do we do that? So we want to provide you with some more clear examples on how to do that. So that will be a bit later. Sorry, Stephen, you've been very patient. I'm going to come to Stephen next.
Thank you. It was the question on you mentioned it kind of right at the end there about recording. We've had discussions about it. In fact, I've had them going back years, really, having been in Lambeth for a while. I totally get that we are, there's not a question about us doing mental capacity assessments for every manner of decision that the person needs to take, and when we have reason to believe that somebody lacks capacity. So this can be every assessment, every review, every care plan, every piece of equipment or adaptation, any decision which needs to be made. We are using the principles, we're thinking along those lines, but the question still is about how we are documenting those, because from discussions previously with other kind of social work managers, the MCA work step on Mosaic was being used in a fairly kind of, not so often. Basically, it was mainly for the bigger decisions. It was around where do I live, what, finances and so on, and not necessarily for the other ones around, the general assessment stuff. And I don't know if that is, I don't feel that I've had sort of, clarity really on behalf of OTs or social workers about when do you use that MCA work step for every case like this, or do you use, is there another proportionate way of doing it? And if there is, what needs to go into that? Because there's still quite a bit of information which should go into that, which means that we're protected from liability if any sort of conflict comes up.
I mean, for instance, there can be a lot of things covered in a care and support MCA. So you can, it might be that you can determine within a one-off, and if they're unlikely to regain capacity, you do have to make a judgment. We can't do it on every decision, and more complex decisions require more complex assessment. And it is around judgment. If there is a risk, if there's something that may happen to them through not having that, you might need to break it down further. But it might be that you do a more broader assessment around consent to have adaptations or support with different things, and you might do one more catch-all MCA. It does depend, and it is about having a discussion with a manager or myself, if needed, to see whether you feel that they should have that. We can't do it for everything, and we can't do it for all things. It is about trying to really capture it when we are going to be making probably a quite restrictive decision, or no, so not a least restrictive decision, but we're going to be making a best interest one possibly, or there is a risk. So we need to do it. But like I said, with all stages, it might be that we capture it in the notes, like most doctors do, like most nurses do, to say we've done a test and we understand that they understand what they are asking for, and they may not. It really does vary person to person, Stephen. So I'm happy to talk about it more though out here if you want, about MCA and when we might need to do it with your team, because it is different for each person. If that's okay.
Okay. Yeah. Yeah.
No, but yeah, just so we're clear, because I'm happy to as a lead around that. That's no problem. Malvina.
I've actually forgot. Oh, so the example that I was going to ask, like, what would you advise in this scenario? So you've got someone in like a supported living setting, semi-independent. They are sexually active, but refusing to go for sexual health checks and refusing to use protection.
Yeah. Okay. I mean, it's quite tricky when people are making daily decisions and you're not sure what those are or how they do it. We can't usually, people have the right to a private life, and they have a right to privacy and family life as part of the Human Rights Act. So what we can do is make steps to check in with them, have them see a GP or nurse. They might need to do some discussions with them around sex, and you might need to do some support around relationships and look at that. Do they understand it? But we're not able to step over that line sometimes, and it might be that we are not clear what is happening and whether they understand that. So it can be quite tricky with those. But yeah, we would expect a health professional from some, and sometimes it might be someone that knows them well and their accommodation. So there's lots of different elements. But yeah, it's quite tricky, and there's been quite a lot of court protection work around it.
Yeah. Thank you.
I'm aware of time, so I'm just going to now pass over to Jenny, who's going to just do a poll just around today's session. I just want to say thank you for everyone's involvement and being so lively with your questions as well. So if you can answer the poll, and we're going to conclude there, but we've got a whole week of sessions, so please do come to the rest of the week. And we've got lots of different sessions on, so we'd love to see you there. Thanks all.